Good afternoon, everyone, and welcome to IBAC's Public Interest Disclosure Forum. My name is Bruce Rago, and I'm the manager of the Engagement and Early Resolution team at IBAC. I would like to begin by acknowledging the traditional owners of the many lands that we are on as we meet today. I'm speaking to you today from the lands of the Wurundjeri people of the Kulin Nation. I pay my respect to their elders, past and present, and extend my respects to members of Aboriginal communities who may be attending today. Today's forum will focus on public interest disclosures, particularly the key obligations public bodies have under the PID Act. We hope that today's forum will provide you with some practical tools and insights to strengthen your existing systems and maintain a working culture free of corruption. We are joined today by speakers who will share with us their insights and strategies around this topic. Our speakers are Alison Byrne, CEO IBAC, Fleur Taylor, Director, Public Law, Policy and Oversight IBAC, and Vesna Allen, Chief Integrity and Compliance Officer, Geelong City Council. Now, some quick housekeeping before I hand over to our first speaker. Given the confidential nature of PIDs, we cannot answer questions on actual PID matters, individual cases, or provide legal advice during this event. This webinar is being recorded, and we will share PID resources and links with you via email following the forum. You can turn on closed captions in the meeting controls if you like. You can also click interpretation to see Auslan interpreters. During this presentation, we will be using Slido. You can join using the link, and details are found in the chat. You are not required to download the app. The question and answer function in Zoom is also active. Please submit any questions you have during the session, and we'll answer them after the presentation. Questions can also be submitted anonymously. I will now hand over to our first presenter, Alison Byrne, IBAC CEO. Alison joined IBAC in August 2024 and has over 25 years of experience in criminal law and regulation. She previously worked as a Chief Executive Officer of the County Court of Victoria. Alison will speak today about IBAC and how the integrity system and the PID scheme intersect.
Thank you, Bruce. Good afternoon. As many of you already know, IBAC is Victoria's anti-corruption agency and police oversight body. Our purpose is to prevent and expose public sector corruption and police misconduct. And we do this through a variety of activities, through our investigations, through our review of external investigations, through our education and, of course, research activities. Now, we're independent of government and we're accountable to the people of Victoria through the Victorian Parliament. IBAC is part of Victoria's integrity system, along with the Victorian Ombudsman and the Victorian Auditor General's Office. There are several other agencies that support the integrity system in Victoria, and they're listed on the slide that you can see now. Now, let's explore the importance of the PID scheme, which is an essential ingredient in the identification and exposure of improper conduct in the public sector. IBAC is responsible for assessing public interest disclosures to determine if they're a public interest complaint under the Public Interest Disclosure Act. Now, I'll be using the term, probably along with the others, PID, to cover public interest disclosures. Now, the PID Act aims to encourage and facilitate disclosures of improper conduct and detrimental action within the public sector. I'm just going to pause there and say that again because it's really important. Encourage and facilitate disclosures by ensuring that those who make disclosures are protected. The disclosures can be properly assessed and investigated, and the content of disclosures and the identity of the discloser is confidential. Now, we understand that the PID scheme is complex. Please contact IBAC if you have any questions. And of course, that contact can be confidential. You can also refer to our PID Act guidelines on our website, and we'll be sharing those guidelines with participants after this webinar. So, what is a PID and what can a PID be about? So, public interest disclosures are reports about the improper conduct of a public officer or public body, such as corrupt conduct, and detrimental action against a person in reprisal for having made a disclosure, a public interest disclosure. PIDs can be made about public bodies, public officers, or, importantly, the conduct of a person who is not a public officer and is not employed by a public body where their conduct adversely affects the performance of a public officer or a public body. So, for instance, a consultant working in a public agency affecting the activities and the performance of that agency, or a contractor affecting the performance of a public officer. Disclosures can relate to conduct or action that may have already taken place, is occurring now, or may happen in the future. Anyone can make a disclosure about improper conduct or detrimental action. Disclosures can be made by individuals or groups of people, but importantly, they can't be made by a company or a business. So ABC Proprietary Limited can't make a disclosure, but the officers or the employees of ABC Proprietary Limited can. A PID can be made via a verbal disclosure, a written disclosure, and of course it can be made anonymously, whether it's verbally, by an unidentifiable or verifiable email, and again face-to-face. Now, PIDs can be made to organisations that can receive disclosures, which includes IBAC, the Victorian Ombudsman, and of course councils. There's a full list of the agencies and the entities that can accept disclosures in the IBAC 2025 PID Act guidelines, which, as I've said, are available on our website and will be shared after this webinar. Finally, I know that there's many PID coordinators who have joined us online today. So thank you for your vital part and role in protecting people who make disclosures in Victoria. The role of a PID coordinator is so important. And that's because you're receiving disclosures and by and large you're responsible for managing those disclosures as well. And you're the best person who can educate others as to the PID scheme. It's significant to note, of course, here that the role of the PID coordinator is set up under the PID Act. So the Act sets out a list of specific people who are able to receive public interest disclosures on behalf of an entity. That means that PID coordinators have significant responsibilities. It's important for PID coordinators, therefore, to be familiar with procedures and the broader PID scheme, including the definitions of terms such as accessible disclosures, public interest disclosure, improper conduct, and detrimental action. You should also know about the available protections and, of course, welfare considerations for persons making disclosures, and how to handle disclosures, when to report them to IBAC. PID resources, including the 2025 PID guidelines, e-modules, and various resources about how to make and when to make a disclosure and how to help witnesses in consideration of their welfare are available on the IBAC website through our resources tab. And again, if you have any questions, please give us a call. So that's it from me. Thank you, Bruce.
Thank you, Alison, for your introduction to the Public Interest Disclosure Scheme. I'm now pleased to introduce our second speaker, Fleur Taylor, who will discuss the Public Interest Disclosure Scheme in more detail. Fleur is the Director of IBAC's Public Law, Policy and Oversight Branch within IBAC's Legal and Compliance Division. This branch is comprised of administrative law experts, PID lawyers, policy writers, and compliance officers.
Thank you, Bruce.
As mentioned, it's my job now to drill down a little bit further into some of the key aspects of the Public Interest Disclosure Act. And I'm going to start by looking a little bit deeper into the definition of improper conduct. Unlike the definition of corrupt conduct in the IBAC Act, improper conduct does not have to involve criminal offending. It also includes conduct that might constitute serious professional misconduct, intentional or reckless breach of public trust, and substantial mismanagement of public resources by a public officer or a public body in that capacity. Whilst the bounds of improper conduct are really only limited by the imagination of those who choose to engage in it, some common examples of improper conduct might include fraud, accepting or offering bribes, misusing a position of authority for personal gain, helping a personal connection to get a job or a contract by not following proper processes or giving inside information, and using government property for personal gain. Now, it's important that although disclosures might not necessarily be able to say unequivocally that that conduct that they're disclosing falls within those specific categories, it's an important feature of the PID Act that a person making a disclosure is only required to have a reasonable belief that the information shows or tends to show that that conduct is occurring. So we'll move now to the term detrimental action. Detrimental action includes action causing injury, loss or damage, intimidation or harassment, discrimination, disadvantage, adverse treatment in relation to a person's employment or career. But importantly, it will only be detrimental action if it is taken or threatened in reprisal for someone making a public interest disclosure, or in the belief that they've made a public interest disclosure, or in the belief that they're about to make a public interest disclosure, or for cooperating with the investigation of a disclosure, or even in the belief that they may have cooperated with such an investigation. Detrimental action also incorporates or covers inciting or permitting another person to take that action. Everyone has the right to make a disclosure about improper conduct, and subject to some limited exceptions related to the provision of false information, everyone who chooses to do so is protected under the PID Act from having detrimental action taken against them for making a disclosure. It is a criminal offence to take detrimental action against another person in reprisal for a PID, proceedings for which may be brought by IBAC, Integrity Oversight Victoria, or a police officer. Now, moving on to receiving and notifying. If a disclosure is made to one of the receiving entities that Alison referred to earlier, a list of which are in our guidelines, if a receiving entity receives a disclosure in accordance with the procedures that they are required to have under the PID Act, and if that receiving entity considers that the disclosure may meet the definition of a PID, that entity must notify IBAC within 28 days. There is a no wrong door policy built into the PID Act, which means that even if the disclosure is made to the wrong receiving entity, it must still be notified to IBAC if that entity considers that the disclosure meets the usual threshold for notification. It's important to note that all notifications to IBAC, even those that we determine not to be public interest complaints, are valuable to us for the purposes of understanding emerging patterns and trends. Also importantly, and in line with the purposes of the PID Act, receiving frequent notifications from an organisation we see as a positive sign of a speak-up culture. It shows the people within your agency are comfortable coming forward. Now, there are several legal protections that are automatically afforded to people who have made a public interest disclosure, as well as the protection against detrimental action that I've already spoken about. There are protections from civil and criminal liability for making a PID, protections for breaching secrecy or confidentiality obligations that you're otherwise intended to maintain, and there's also a defence of absolute privilege in any proceeding for defamation. There are, however, limits to these protections. They do not apply, for instance, if a person provides false or misleading information in making a PID, and they also do not allow a disclosure to avoid liability for their own conduct simply by disclosing that conduct under the PID Act. An important, though sometimes tricky, aspect of the PID Act are the confidentiality obligations contained in Part 7 of the Act. These confidentiality obligations cover the content and information about the content of the disclosure, as well as information likely to identify the person who made the disclosure. So what do the confidentiality provisions mean? Essentially, once a person makes an accessible disclosure, or once a person or entity receives information about an accessible disclosure, the person or body in receipt of that information must ensure that the content of the disclosure and the identity of the discloser remain confidential unless an exception applies. Importantly, the applicable exceptions, which are also contained in Part 7, must be considered on a case-by-case basis. That is, each time you're thinking about possibly disclosing information that would be subject to the Part 7 confidentiality obligations, you will need to satisfy yourself in each circumstance that one of the exception applies. It's important to note that the confidentiality obligations in Part 7 of the PID Act do not apply to the person who made the disclosure. And finally, if you're ever in doubt about your confidentiality obligations under the PID Act, please consider seeking legal advice, as the case-by-case consideration of the exceptions particularly can be quite complex. And that's it from me. I'll hand back to Bruce.
Thank you, Fleur, for deepening our understanding of the public interest disclosure scheme. I'm now pleased to introduce our third speaker, Vesna Allen. Vesna is a lawyer and the Chief Compliance and Integrity Officer at the City of Greater Geelong. She's an experienced executive legal advisor and governance specialist and non-executive director, having served on not-for-profit and public sector boards, including YMCA and HES Rural Health. Vesna will discuss the practical applications of the public interest disclosure scheme.
Thank you, Bruce, for that introduction. I would first like to start off by acknowledging the traditional owners of the land, waterways and skies from where I'm from, the Wadawurrung people, and pay my respects to their elders past, present and emerging. Quite often when we talk about public interest disclosures, it's very easy to get stuck on the legislation and the process. But at the end of the day, a disclosure isn't just about a document or an allegation. It's a person who's decided to put trust in a system and take a risk by coming forward. So our job here is twofold. Firstly, we must manage the information carefully, ensuring accuracy and confidentiality. And secondly, we must support the individual who's come forward, recognising that it takes courage and vulnerability. If we get both of these right, we not only meet our legal obligations, but we also build trust and integrity in our organisation. Every disclosure is a moment of vulnerability for someone. How we respond can have a lasting impact, not just on that individual, but on the culture of our workplace. So if you're unsure, treat the information with care and escalate it to your your protected disclosure coordinator or to IBAC. It's better to err on the side of caution than risk missing an obligation. Don't try and make a determination yourself if you're unsure. There are established processes and pathways that you can use. The first priority is getting our information down correctly. It's really important to not add colour or interpret. Just record what's being said, word for word. And please do not use ChatGPT to assist with your record keeping. There are plenty of examples available on how the use of open AI tools have resulted in significant compliance failures in the public sector. It's important also to limit who has access to the information. Only those who need to be involved should see it. This protects both the integrity of the process and the privacy of the discloser. You also need to ensure your information is properly classified. Even if you're not sure if it is a PID, escalate it to your coordinator or to IBAC to decide. And finally, it's important to act quickly. Sitting on a disclosure can be just as damaging as mishandling it. Delays can undermine a discloser's confidence and can also introduce additional risks. A timely response shows respect for both the process and the person and helps maintain trust in the system. Confidentiality is critical, but there can be limits. Be honest with your disclosure about what you can and can't guarantee to them, and only share information with those who need to know, and explain why escalation may be necessary. This transparency will build trust even when you can't promise absolute confidentiality in all instances. Managing the disclosure is just as important as managing the information. Start by acknowledging and thanking the person, because it really takes a lot to come forward, and this should be recognised. Explain the process in plain terms. What happens next, what you can tell them, and what you can't tell them. Be honest about what you know, but also what you don't know. Keeping in touch is very important as well. Silence is one of the main reasons people lose faith in the system. Even a brief update and a check-in can make a big difference. Also, don't underestimate the emotional toll. Make sure people know that there are support options available, EAP or your HR department, and consider whether workplace adjustments are needed to protect them. Our support can make a significant difference to their experience and their willingness to trust the process in the future. It's also very important to take all concerns about reprisals seriously, even if they seem minor or indirect. Document concerns and offer the support options that I've mentioned before, and monitor situations and check in with people regularly. Early intervention is important to prevent harm. Even if there's no new information to pass back to a disclosure, a brief check-in can reassure them that their matter hasn't been forgotten. That silence can be one of the main reasons people will lose trust in the system. It's also very important to explain what your obligations are under the PID framework. Sometimes you may be required to act, even if the person doesn't want you to. But it's important to be empathetic, explain the process, and reassure them that their well-being will be supported throughout. There are some pitfalls that can befall us sometimes. One is dismissing a complaint as just a complaint and missing a PID obligation. Every disclosure you receive should be given careful consideration. Another pitfall is overpromising, saying things like this will stay completely confidential when in reality you may need to pass it upwards. Be realistic and transparent about what you can guarantee and what you can't. A big one is also forgetting the disclosure once the referral has been made. You might have checked off all the legal tick boxes, but they can often feel abandoned if you don't keep in close connection and follow up with them. And of course, remember, reprisals don't always look like demotions. They can be subtle, like gossiping or exclusion from meetings or being sidelined. Encourage your managers and people leaders to be proactive and intervene early if they notice these behaviours. Avoiding these pitfalls protect both the individual and the integrity of the process and helps foster a culture of trust. So what does good practice look like? Always start with a clear referral pathway. Flowcharts, checklists, guides can help everybody know what they need to do, who needs to do it, and reduce uncertainty. Train your managers and leaders to pick up on potential reprisals or detrimental action and to action them early before harm occurs. Be sure to keep secure and auditable records of how the disclosure has been handled, including decisions and actions that you've taken. Be upfront with your disclosure, particularly around the limits of what you can share, but don't vanish on them. As I've said before, short check-ins can make a big difference. And finally, make it a part of your culture to value disclosures. Disclosures are not a problem to be managed. They're a sign that your integrity systems are working and that people feel safe to speak up. These will lead to trust and resilience in your organisation. So my key takeaways today, there are two important puzzles of the PID process. One is managing the disclosure, which is about protecting the information, and the second is about managing the disclosures, which is about protecting the people. Both need care, structure, and communication. How you respond to a disclosure will set the tone for whether others feel safe to come forward in the future. And if you remember nothing else from today, which I'm sure you will, please remember this. Treat the information seriously and treat people with respect. That way, you will ensure that your response is the way people will trust the system next time. Thank you, Bruce.
Thank you, Vesna, for sharing your insights with us about the practical applications of the public interest disclosure scheme. I will now introduce you to a PID scenario, which will be followed by some questions that you can answer via Slido or in the chat. We'll have some time following the scenarios for some questions and answers. If you have not already accessed Slido, please do so now, and you can join via the link in the chat and by entering #PID on Slido. So we will now go through a case study that you might come across in your role as a PID coordinator. So the scenario is, as a public interest disclosure coordinator, you receive an email from an employee, and the email discloses the following. The employee tells you that they have previously made a complaint that was also a public interest disclosure about their line manager about 12 months ago. The earlier complaint related to the manager's friend who works for a developer doing some work on the manager's house for which they used some council equipment. The matter was investigated. The employee has continued to report to the line manager. So the employee was advised by their manager that due to a restructure, the employee's position was no longer needed and they would have to go through a redundancy process. The employee is the only role affected. All other roles are being redesigned. No one else is being made redundant. The employee tells you that since the investigation, their manager has been cagey and distant. The manager never meets with this employee and will often avoid the employee. It has been a stressful 12 months, and the employee feels that they are suspected of causing the investigation. The employee feels the manager wants to get rid of them. The employee also tells you that they are busy at work and there has never been any concerns with their performance. So the first Slido question that should appear on your phones. As the PID coordinator, would you make any further inquiries to determine if the disclosure could be a public interest disclosure? And I'll give the audience a chance to respond. And I can see a lot of us have selected yes. So some of the inquiries that you may wish to make is if there's anything unclear in the disclosure that's been made, you may wish to get clarification. As Vesna talked about welfare considerations, this is also something that you may wish to make some inquiries with the discloser to see if they are doing well following this disclosure and they're stressed, offer them EAP. It's important to note not to commence an investigation at this point in time. You may ask clarifying questions, but do not commence an investigation within your agency, and it's important to notify IBAC as soon as you receive this disclosure. So the second question then is, as a public PID coordinator, do you consider this information may be a public interest disclosure? And I'll give our participants an opportunity to respond. So this time we're seeing some varied responses, but the majority going with yes. There are a couple of no's and some unsure's. So in this scenario, we would consider that this is a public interest disclosure. The complaint is about detrimental action being taken against the employee who has previously made a public interest complaint. And the complainant here has presented with a reasonable belief that their manager may be targeting them for having previously made the public interest disclosure. Any reasonable person in the possession of the same information that they've provided about being excluded, about the redundancies, they would also likely form the same conclusion that their manager, that they have a reasonable belief that their manager taking detrimental action against them. So, what would be your next steps regarding this matter? And please note that this question you can select multiple responses in Slido. All right, so we've got a couple of responses in. Notifying IBAC immediately, absolutely. Once this has come in, once you've got all the information you need, notify IBAC. And now we've got maintaining the confidentiality of the disclosure as well at 93%. Certainly, we want to make sure the person's identity is protected. The PID scheme invites people to come forward with these matters, so maintaining their confidentiality is imperative so that further disclosures are confident in the way disclosures are managed and it's managed in a confidential way. There are other options selected that are not as popular about sharing the complaint with their manager. We would not want to do that because they are concerned that their manager is the one taking detrimental action against them. So we would not want to share that information with their manager because that could expose them to further detrimental action. And the same thing, we would not try and contact the executive and seek advice disclosing the name of the employee because we don't know how that information could then subsequently be passed on. And then that would go against maintaining the confidentiality of the disclosure and the disclosure that they're making. All right, the next question we'd have is, what welfare considerations would you put in place? Right, and so now I can see there are three popular responses here. Again, maintaining confidentiality being the first one, absolutely, as we previously discussed. With this scheme, we want to encourage disclosures to come forward, and maintaining confidentiality is important. And as well, making the employee aware of support such as EAP, because this can be quite a stressful process. And we want to support them as well during this process. The third option, providing practical advice to employees about the PID Act. This can be quite a complex process and they may not understand what rights, protections, obligations they have, especially given that they've already made a public interest disclosure in the past and now they're having further adverse action taken against them. So this is an opportunity for you to provide them with guidance that you know. And I'm glad no one's picked the last option about sharing the details on Teams because that would go against the maintaining confidentiality principle. Okay, so now we have a few more minutes for some further questions. And we'll go through some that have been submitted. So the first question is, how long does it take for IBAC to assess a notification? It does depend largely on how complex the notification might be. Within IBAC, once we get a notification, we aim to allocate that to a case manager within the same week. And then depending on the complexity of the notification, this can be finalized within 1 to 3 weeks. Sometimes we might need to go back to the discloser or the referring agency to conduct further consultations, but we aim to get them done within 1 to 3 weeks. I do recognize that sometimes when you do make a notification to us, there may be urgency attached to that. So when you do send in a notification to us, if you do highlight the urgency of the matter, we will ensure that our case managers prioritize that notification and get you a response as well as the disclosure. The second question that was submitted is, how do people access the public interest disclosure scheme online? So if you go onto IBAC's website, there is an option for you to submit complaints as well as disclosures on our website, and that's the process that which you can submit the public interest disclosure. As Alison's also previously mentioned, you may just wish to contact our office if you're not sure, and our officers on our phones can provide you with guidance if you're not sure. And we've got a question, could staff at public schools be covered by the PID scheme? And I might hand over to Fleur for this question.
Thank you, Bruce. So in short, yes, staff at public schools are likely to be public officials for the purposes of the PID Act, and therefore they may, if they have engaged in improper conduct or detrimental action, then yes, I would encourage people to come forward and make disclosures about that type of conduct. Again, the threshold is a reasonable belief. So as long as you have a reasonable belief that those staff at those public schools have engaged in improper conduct or detrimental action, then it is important to come forward.
Thank you, Fleur. We've got another question. Are there any limitations on the anonymity of the disclosure or whether the disclosure qualifies as a PID? PIDs can be submitted anonymously. We understand people may be worried about their identity being disclosed and any potential detrimental action being taken against them. So there is no limitations on whether someone has to be named. They can be submitted anonymously, and we will assess the matter accordingly. It does not affect whether a matter is then later classified as a public interest disclosure.
I might just add, Bruce, sorry if I can take a moment, that whilst there is no limitation on anonymity and it is possible for disclosures to make anonymous disclosures, the ability of receiving entities and IBAC especially to assess the disclosure under the Public Interest Disclosure Act can sometimes be limited by the anonymity itself. So, and that's a roundabout way of saying, if we don't know how to contact an anonymous discloser, then it limits our ability to get in touch and clarify or verify some of the information provided, which may then lead to a different outcome than there may be if we had the opportunity to contact and verify some of that information. So that's just an important practical aspect to keep in mind.
Thank you, Fleur. We've got a new question. What is IBAC's process for assessing whether a PID, a public interest disclosure, is a PIC, which is a public interest complaint? Are there criteria to be followed? Noting that in the PID Act, the description of a public interest disclosure and a public interest complaint appear practically identical. Might hand over to Fleur.
I was hoping you wouldn't, but thank you, Bruce. The person who submitted the question is absolutely right. The definitions or descriptions of public interest disclosure and public interest complaint are practically identical, and for all intents and purposes, they have the same legal meaning. The difference, I suppose, is that from the way that IBAC sort of interprets it, is that a public interest disclosure, whether or not a disclosure is a PID, is really an objective fact, a sort of jurisdictional threshold, if you will. It is then up to IBAC to make a determination under Section 26 of the Act, which is whether we think certain thresholds are made, as opposed to the jurisdictional threshold being met in, I think, Section 9. It is fairly complex, involves a little bit of mental gymnastics when we're conducting our assessments, but that is the overall difference.
Thank you, Fleur. So we've got a new question. If conducting an investigation under a separate process under an act, and a person in the investigation identifies themselves as having made a PID to IBAC, what should you do? So I'm assuming this question means that if someone discloses to you that they have made a PID to IBAC as part of a separate investigation, what should you do? I think that would pretty much relate to the first question that you'd ask is what further information, what did they intend by telling you this information? Are they trying to make a new disclosure to you? Are there any welfare considerations? Ask questions about whether there's any confidentiality obligations that might have been breached. This would be a good opportunity to also consider their welfare and well-being, but turn your mind to any other, whether this now needs to be reported to IBAC if a person's information has been inappropriately disclosed, and whether they're experiencing any detrimental action.
And if I could jump in there, Bruce, I think it's important to note that a person who has made a disclosure is allowed to discuss that disclosure. The protection is about them and the information that they give in a disclosure. The protection does not prevent them from seeking support and sharing information with certain people, like a partner, a legal practitioner or a healthcare practitioner. So if you're in an agency or a council department and someone says to you that they have made a PID to IBAC, they're not doing the wrong thing. But there will be confidentiality, as Bruce said, around it, more than likely. So as Bruce said, check in on them. Are they actually asking for help from a welfare perspective? But then you can always suggest to them to speak to IBAC about that previous disclosure if you're concerned about whether you should know about it or not too. We're here to help.
All right, thank you, Alison. So the next question we have is, are counsellors covered for this PID or IBAC? So yes, counsellors essentially would fall under, so as Alison previously mentioned, PIDs can be made about public bodies, public officers, and the conduct of any person who is not a public officer, where their conduct adversely affects the performance of a public body or an officer. So counsellors would be considered as public officers, so IBAC can receive complaints about counsellors. And finally, our last question is, can you elaborate a bit more on PIDs being made against people who are not employees but adversely affecting a public body? So at the end of the day, if someone might not be working as an employee of a government body, but they may be a contractor, a consultant who's being paid to do a government role, if they may be engaging in certain conduct that can then affect the performance, the effective performance of that public body's work, part of a tender process, or even after receiving funding for a project, then misusing that conduct, if they're still impacting the adverse effect of a government body, we would still then consider that a PID can be made about those individuals.
I can jump in there. Sorry, Bruce. I think it'd be important to have a look at some of IBAC's special reports in relation to that question. So as Bruce said, and I've said previously, talking about contractors and consultants, but there are also people that we've exposed through our investigations and our special reports who were not engaged in a lawful contract, like a contractor or a consultant, but in fact were engaged in unlawful activities, bribery and so forth of a public official and body. So it might be that person A goes up to a counsellor and offers money for, particular benefit to their business. It might be that person B approaches a public sector body with promotional activities or gifts for that person in the public agency's children and the like. So they're not engaged in a lawful contract as such, but they're still adversely affecting the public body or the public officer involved.
Thank you, Alison. I'd also now just like to invite the other panelists if there's any final takeaways that they would like to share. Fleur?
Sure, thanks, Bruce. I suppose the final takeaway from me would be just a reminder that what I spoke about earlier, the confidentiality obligations under Part 7 of the PID Act are particularly complex and do get quite confusing in practice. So it is important at every turn, every time you're thinking about utilising information that relates to the content or the identity of a disclosure, to really turn your mind to each of those possible exceptions that are listed in Part 7 and really sort of determine on a case-by-case basis whether one of those exceptions applies in those circumstances before you make that disclosure.
Thank you, Fleur. And Vesna, is there anything you'd like to share?
Thanks, Bruce. I think for me, my takeaway would be to never forget that human side of disclosures and the impact that it has on fostering that speak-up culture in your organisation.
Thank you, Vesna. And Alison?
I think we're genuinely of the view that the PID Act is complex. Whether you're a PID coordinator, whether you're someone who has seen something, someone who's involved in a situation, we understand that looking at the IBAC Act, looking at your legislation, then looking at the PID Act is difficult. Understanding the confidentiality rules is difficult. And so recently IBAC has engaged in a hearing with the Integrity Oversight Committee, and our submission said that there needs to be a holistic review of the PID legislation so that we really do focus on encouraging, supporting and facilitating public interest disclosures. So stay tuned for an update on that.
Thanks, Alison. And my final takeaway, building on what Alison said, this is a complex area of the law, and if you are not sure, please reach out to our office. We're here to help. So this is all the time we have for today's webinar. IBAC has many PID resources available on our website. We will share some of these with you following this presentation, such as the IBAC PID Welfare Guide. The slides from today's webinar will also be shared with you via email in the coming days. So to find out more about upcoming IBAC events, you can subscribe to our Insights list on the IBAC website. And finally, as this webinar comes to an end and as you exit Zoom, you will see a link to complete a short feedback survey, or you can use the QR code on the screen to access the survey. All feedback we receive from these events is taken seriously and it helps shape our future events. We look forward to seeing you again at a future IBAC event. Thank you and bye for now.